Swayam Prabha. Digital India. Educated India.
Good afternoon everyone. Welcome to the NPTEL online certification course, our course titled Medical Law. Myself Dr. Chaitanya Mittal here as Assistant Professor and Medical Legal Expert at Dr. B.C. Roy Multi-Specialty Medical Research Center, IIT Kharagpur. As you know, with the previous lectures we were on the week 7, the assistant reproductive techniques and surrogacy. So, today we will be discussing on the lecture 34 the topic preconception and prenatal diagnostic, that will be as PC-PNDT Act. So, the various topics or the concepts which we will cover in this lecture are the sex selection, historical context of the sex selection, about the PC-PNDT Act 1994 and the further amendments which have been there in the Preconception and Prenatal Diagnostic Techniques Act. What are the objectives of this act, the key features and the judicial approach to the act, and then we will be discussing on the various news or the articles related to this topic. The keywords involved in this lecture: the sex selection, fetus, feticide, sex determination and the diagnostic techniques. The introduction of this lecture. So, what do you mean about the sex selection or how it is important in the society? So, the sex selection of the fetus, particularly the preference for the male children, has been a persistent issue in India with significant social, cultural and demographic implications. Even I can say not in India, even underdeveloped and developing countries. So, there are the many perspectives are there in which, because of the society and societal issue of male dominance, that is the need for sex selection is going on in the past years. The desire for male hires coupled with culture preference and economic factors has led to the misuse of prenatal diagnostic techniques for sex determination while in the womb, and in some cases selective abortion of female fetuses, that is also a like illegal abortion or the criminal abortion being done. So, this practice has contributed to an uneven sex ratio in certain regions of the country with a higher number of males compared to females. So, there should be or even must mandatory to be the prohibition of sex selection, which have been we will be discussing in further slides of this lecture. The sex selection in the context of reproductive health refers to the use of prenatal diagnostic techniques to identify and choose the sex of the fetus. In India, the practice of sex selection is often associated with a strong societal preference for male offspring as the male dominant society, leading to the criminal abortions or the illegal abortions of female fetuses. Female feticide is one of the social evil that exists in the Indian society. Even it is still prevalent in few places or few villages, even sometime in the cities also still exist in our country. Understanding the extent and the consequences of sex selection is significant for developing effective strategies to address this complex and deeply rooted issue in India. The historical context related to the factor influencing the sex selection in India are: the historical context of sex selection in India reveals a complex interplay of cultural practices and social norms that have evolved over generations. Within Indian families, the desire for a male child can stem from the belief that the sun provides security in a old age, carries the female name and performs religious rituals or other culture and societal norms. Because of that, this sex selection goes on and leading to the male dominant society. The impact of technology, the accessibility of prenatal diagnostic techniques has facilitated sex selection, making it a more widespread and commercial practice even for the societal perspective, for the common people who are misusing these techniques, and even it is being misused by the medical practitioners as they know how to do the prenatal diagnostic techniques, and for the small amount of money or any gift they are performing such a bad prenatal diagnostic techniques, leading to the criminal abortion and doing the female feticides. So, to curb this social evil of female feticide, steps have been taken at the national and international levels. In India, Maharashtra was the first state to enact legislation called the Maharashtra Regulation of Prenatal Diagnostic Tests in 1987. Thereafter, in 1994, the Prenatal Diagnostic Techniques Regulation and the Prevention of Misuse (PNDT) Act was enacted at the national level to ensure the prohibition of female feticide and to regulate the use of prenatal diagnostic techniques properly, in which it is really required, like determining any abnormalities while pregnancy, but not for the female feticide or knowing the sex selection. So, coming to the what are the amendments happened. So, first amendment happened even in the name to be the addition of preconception in the PNDT. So, the new term comes as preconception and prenatal diagnostic techniques, that is PCPNDT Act 1994. The Indian government approved the prenatal diagnostic techniques, that is the regulation and the prevention of misuse PNDT Act in 1994. The act came into force on January 1st, 1996. Through the amendment of 2002, which was passed in 2003 to the PCPNDT Act 1994, that is preconception and prenatal diagnostic techniques, that is the prohibition of sex selection, came in 1994, being amended into the 2002, which was passed in 2003. The amendment covers the techniques of preconception, sex selection and ultrasound. So, the various mentioned the regulations in the PCPNDT Act 1994, the act lays down certain objectives for its functioning. So, first and foremost, to curb the social evil, that is a female feticide. So, first and foremost objective is the prohibition of sex selection. Second, to provide the procedure for the registration of genetic counseling centers, clinics and laboratories. It also prohibits the sale of laboratory equipment used for ultrasound to any person, clinic or lab that is not registered. It is must to have AERB registration to even purchase and install the laboratory equipment to perform the PCPNDT techniques. So, it is mandatory to have a registration of that particular clinic or a hospital with the help of a medical practitioner, that is a radiologist, or who is being eligible to do the ultrasound and PCPNDT Act. It prescribes the procedure for conducting prenatal diagnosis. It also contains a punishment who violates the provisions and rules made under the Act. So, these are the objectives: to follow the various regulations and mandatory to follow the objectives of this Act, and those who does not follow or violates it, and there is a specific penalties related to it. The Act has three aspects. So, what all are the prohibitions, regulations and the preventions. So, what all mean the prohibition is the sex selection completely either before or after, that is a preconception or prenatal. So, the sex selection is completely prohibited. It is not at all allowed. Those who does so, it is a punishment. Regulates the use of prenatal diagnostic techniques for legal or medical purposes, or to determining any anomalies occurring while pregnancy, any fetal anomalies. For that purpose only the PCPNDT, the techniques being done under this act, and the prevention the misuse of sex determination which leads to the female feticide. So, should not do the any criminal abortion. So, these are the three main aspects of this act, PCPNDT act. So, the key features, what are all the key features of PCPNDT act is the under section 2. So, fetus, what are the important definition? So, what for whom we say the fetus? Fetus means a human organism during the period of its development beginning on the 57th day following fertilization or creation. The genetic counseling center means any institute, hospital, nursing home or any place which provides genetic counseling to patients. Genetic clinic means a clinic, even institute or hospital, nursing home or any place which is used for conducting prenatal diagnostic procedures. Genetic laboratory includes a laboratory or any place where the facilities are provided for conducting analysis or the test of samples received for prenatal diagnostic tests from genetic clinics. But these all centers or either clinics or the laboratory should be registered under AARB. So, here comes the registration which I was talking about, the registration of these centers, laboratories, clinics, which comes under the section 3 of this act is regulates the conduct of genetic counseling centers, clinics, laboratories, gynecologists and registered medical practitioner who can perform these PC and PNDT techniques. It mandates the registration and regulates the genetic counseling centers, clinics and laboratories to conduct activities relating to the prenatal diagnostic techniques. It also prohibits gynecologists and registered medical practitioner from conducting activities relating to prenatal and diagnostic techniques at a place other than the registered under the act. So, the medical practitioners who are being allowed or who are eligible to do the ultrasound and other techniques should perform the activities only in a registered place, not other than else. Otherwise, they will be held liable for particular violation of that act which comes under section 3 and they will be punished accordingly the act done by them. So, how to register, which comes under section 18 of this act. So, how we can register the genetic counseling centers or either laboratories or the clinics to render service provided under the act. Every center or clinic or laboratory shall apply for registration within 60 days from the commencement of the act, that is Amendment Act 2002, Act 14 of the 2003, section 17, which effective from 14th Feb 2003. It is very easy to remember the date. So, that is the year 2003, 14th Feb 2003. The appropriate authority is the granting authority of the registration certificate and it can suspend or cancel the certificate if there is any violation of the act at any particular point of time whenever they visits or any for a regulation visit, whenever being inspection being done at the clinics or the centers. If there is any violation, they can suspend or cancel the registration going on. So, it is mandatory to have the registration certificate from the appropriate authority by the centers who are performing any genetic counseling, genetic tests, genetic laboratories or the clinics where the ultrasound being done. So, coming to the one of the famous judgment of a year 2013 in a Sadanand M. Engle versus State of Maharashtra, that is a Bombay 697, the Bombay High Court held that the act requires the appropriate authority to form an opinion based on some objective material that it is necessary or expedient in the public interest to suspend registration of a genetic clinic or a center. The provision also mandates the appropriate authority to record reasons in writing. This provision stands on its own footing, empowering the appropriate authority to suspend registration for a temporary period or even cancel it without even issuing a show cause notice and giving a reasonable opportunity of hearing to the genetic clinic or center. So, it is very much mandatory to have a registration certificate from the appropriate authority. It is being clearly mentioned by with the help of this judgment Bombay High Court that any center who performs any prenatal diagnostic techniques that should be registered. So, coming to the further sections of the detailing of this act, which comes under section 3A and 3B. So, 3A says it prohibits any person to conduct or cause to conduct sex selection on any woman or man or on both or on any tissue, embryo or gametes from either or both of them. Section 3B restricts the selling of ultrasound machines, imaging machines, scanners or any equipment capable of detecting of the sex of the fetus without registration. So, the registration is must mandatory, otherwise held liable and punishment. So, these are being mentioned in this act. Only for this purpose the diagnostic techniques can be performed by the medical practitioner or who is being eligible to do the ultrasound. That person can do the techniques on the pregnant mother to detect in the fetus only these mentioned abnormalities or the anomalies. Otherwise, being other things are being prohibited or being the violation if done. So, being the violation of this act and held liable for punishment. So, the previously mentioned PNDT can be used if any of the following conditions are satisfied. The age of the pregnant woman is above 35 years. The pregnant woman has undergone 2 or more spontaneous abortions of fetal loss. The pregnant woman had been exposed to teratogenic agents. The pregnant woman or her spouse has a family history of mental retardation, of physical deformities or genetic diseases or any other condition specified by the Central Supervisory Board. So, if all these conditions are being there or even any one, so it is satisfying to be used as a prenatal diagnostic techniques, then it become necessary to do so. If we have found out any anomalies, so they can go for an MTP. Otherwise, for the other purposes like specific more common being the sex selection, it is completely prohibited, not at all allowed. And if all these things are being there or any doubt or any history, then definitely we can go with an prenatal diagnostic techniques, and accordingly whatever being the report we can perform the MTP as per the MTP Act. So, coming to the section 5 of the Act, it stipulates that no person shall conduct PNDT unless he has explained all known side effects and after effects to the pregnant woman. The written consent signed by the pregnant woman is mandatory. It is prohibited to reveal the sex of the fetus to any person including the pregnant woman or her relatives in any manner. Not at all allowed in even any manner, any sign, any written way, in anywhere. It is not at all allowed to reveal the sex of the fetus, which comes under section 5 of the PCPNDT Act. So, the section 6 of the Act is very particular and stringent for the sex selection. It is unlawful not only for genetic counseling center or genetic laboratory or genetic clinic, but also to any person by whatever means to determine the sex of the fetus either before or after conception. It is not at all allowed, it is unlawful, it is prohibited, it will be held liable for punishment. So, coming to the section 7, which says about Central Supervisory Board. So, who all are included in that? The minister in charge of the ministry or Department of Family Welfare as ex officio chairman. Secretary to the Government of India in charge of the Department of Family Welfare as ex officio Vice Chairman. 3 ex officio members by the central government to represent the ministries of central government in charge of women and the child development, Department of Legal Affairs or Legislative Department in the Ministry of Law and Justice and Indian System of Medicine and Homeopathy. The Director General of Health Services of the central government as ex officio members. 10 members from various medicinal, scientific and social domains. 4 members to represent states or union territories. An officer of the central government in charge of family welfare as member secretary as ex officio. So, these are the following members which take parts of the central supervisory board. So, one being the chairman, another is the vice chairman, 3 ex officio members and other 15 members which are involved or medical experts related to the field. So, must to know about who all are included in the central supervisory board of the PCP Act. So, what all the functions of this central supervisory board which are mentioned in the section 16 of this act? Advise the central government on the policy of PCP Act, sex selection and its misuse. Review and monitor the implementation of the act and the rules. Public awareness against sex selection, PNDT, that is a prenatal diagnostic techniques and female feticide. Lay down code of conduct for persons working in the field. Supervise other bodies created under the act. So, these are the very important functions of the central supervisory board which comes under section 16 of this act. So, we have discussed about the central supervisory board. So, here comes as a state supervisory board under section 16A. So, who all are included under the central supervisory board? So, minister in charge of the health and family welfare in the state, who shall be the chairperson as ex officio. Secretary in charge of the Department of Health and Family Welfare, who shall be the vice chairman ex officio. Secretaries or the commissioners in charge of departments of women and child development, social welfare, law and Indian system of medicines and homeopathy as ex officio member or their representatives. Director of Health and Family Welfare or Indian system of medicine and homeopathy of the state government as ex officio members. 3 women members of the Legislative Assembly or Legislative Council, 10 members from various medicinal, scientific and social domains, and officer in charge of family welfare as member secretary ex officio. So, these are the members which are there in the state supervisory board, comes under section 16A. So, what all are the functions of the state supervisory board are? First, to create public awareness against the practice of preconception sex determination and prenatal determination of the sex of the fetus leading to the female feticide in the state. To review the activities of the appropriate authorities functioning in the state and recommend appropriate action against them if there is any violation. To monitor the implementation of provisions of the act and the rules and make suitable recommendations related thereto the board. To send such consolidated in respect of the various activities undertaken in the state under the act to the board and the central government. Any other functions as may be prescribed under the act. So, these are the various functions of state supervisory board being mentioned in the section 16A and B. So, coming to the section 17, who all are the appropriate authorities? The central government for union territories and the state government for the state respectively shall appoint appropriate authorities. So, who all are comes under as appropriate authorities? It consists of 3 members. So, first an officer of or above the rank of joint director of health and family welfare as chairperson, an eminent woman representing women's organization, officer of law department of the state or the union territory concerned. So, these are the 3 members who make an appropriate authority, who give a registration certificate to particular center or the clinic or laboratory to perform such diagnostic techniques and following the PCP Act, and even if there is any violation, take the particular action accordingly. So, what all are the functions of this appropriate authority which comes under section 17 of 4? To grant, suspend or cancel licenses of center, clinics and laboratories, to enforce standards prescribed for centers, clinics and labs, to take legal action suo motu or brought to its notice, to create public awareness against the sex determination, sex selection and prenatal determination of sex, to supervise the implementation of the act, to recommend modification to the central board as well as the state supervisory board. So, these are the functions of appropriate authorities. So, what are the powers of the appropriate authority being mentioned under section 17A? The summon any person who has information regarding a violation of the provisions of the act, order to produce any document relating to a violation of the provisions of the act, issue a search warrant for any place suspected of indulging in sex selection techniques or prenatal determination. So, it is necessary to use these powers to recheck, keep on checking about the if there is any violation of PCP/NDT Act happening in the particular city, state, country. According to the section 29 of the Act, all records, charts, forms, reports, consent letters and all other documents required to be maintained under this Act and the rules shall be preserved for a period of 2 years or such period as may be prescribed. Better to preserve if any case goes on, preserve till the case get disposed of. If any criminal or other proceedings are instituted against any center, any laboratory or any clinic, the records or all other documents of such center, laboratory, clinic shall be preserved till the final disposal of such proceedings. So, what all are the offences or the penalties who violates this Act? All offences provided under the Act shall be the cognizable, where a police officer can make an arrest and start an investigation without a warrant from the court of law, non-bailable, where only the court has authority to grant bail, non-compoundable, where the victim and accused cannot enter into a compromise and settle the matter. So, these are very important. Whoever the violates the Act or the provisions of the Act or the objectives of functions of the Act, so this is very important offence they are doing, that is cognizable offence, non-bailable offence, non-compoundable offence. So, what all are the penalties? The Act prohibits any person, genetic counseling center, laboratory or clinic from publishing, distributing or communicating any advertisement in any form including the internet regarding facilities for prenatal determination of sex or sex selection. If any contravention is found, it shall be punishable with imprisonment of up to 3 years and fine up to 10,000 rupees as per the section 22 of the Act. So, if any medical genetist, gynecologist, registered medical practitioner or any person who owns counseling center or laboratory or clinic contravenes any provisions or rules made under the Act, for the first offence the imprisonment will be up to 3 years with fine up to 10,000, or the removal of name from the register of medical council for 5 years with a warrant notice. If subsequent offence or repeat offender, the imprisonment up to 5 years with a fine up to 50,000 rupees and permanent removal of the name from the register of medical council, that is a penal erasure of the medical practitioner, permanent or professional death sentence we call. So, permanent removal of the name of the medical practitioner from the medical register. So, under section 24 of the Act, the strongest presumption of the evidence is in favor of the pregnant woman. As per the selection, the court shall presume that the woman was compelled by her husband or relatives to undergo prenatal diagnostic techniques for conditions provided in section 4 of 2. The punishment for the offence is mentioned as imprisonment for up to 3 years and fine up to 50,000 rupees. So, coming to the judicial approach to the Act, which is our last topic or last concept to be covered in this lecture, is to achieve the object of the Act in letter and the spirit. The Supreme Court in Center for Inquiry into Health and Allied Themes, that is a SEHAT, versus Union of India AIR 2001 SC 2007 provided important directions to the central government and central supervisory board to create public awareness against the practice of prenatal determination of sex and female feticide through multiple and multidimensional programs. So, coming to the judgment, in a Vinod Soni versus Union of India of year 2005, Bombay High Court held that the right to life and personal liberty under Article 21 of the Indian Constitution do not envisage a right to choose the sex of the offspring. It further held that the PCPNDT Act was in furtherance of the right of every child, whatever its sex may be, to full development guaranteed under Article 21 of the Constitution of India. In another case, the Saksham Foundation Charitable Society versus Union of India, the petitioner challenged the constitutional validity of provisions prohibiting disclosure of the sex of the fetus, that is a section 5(2) of the Act, and banning sex determination, that is a section 6 of the Act. While dismissing the petition, Allahabad High Court reiterated that PCP and DT Act should follow it. So, coming to the one of the news which is being mentioned in the live law, that is the Delhi High Court has passed a directions for effective implementation of PCP and DT Act, observing there is a need for a safe womb for female fetus. So, observing this to be the act to be implemented with a greater care and utilized by those who are affected. So, the Justice Swarna Kanta Sharma said, sex determination based abortion is a powerful method of perpetuating gender inequalities. The restriction of access to female sex information is directly related to the problem of misogyny, which affects women of all socioeconomic backgrounds, not only in this country but globally as well. The purpose of controlling knowledge of sex or gender is to protect expectant women and their unborn child. Despite the fact that sex selective abortion may not be immediately apparent in the present Act, its primary objective is to address this issue. The court observed that although India has made considerable progress towards achieving gender equality, however, the preference for sex determination still exists. It added that it has been challenging to completely eradicate gender bias despite various efforts. This statement is being made to emphasize the effectiveness of current legislation, and the above observation made by this court are intended to highlight the impact of existing laws and regulation on society. This court aim is to demonstrate how these laws have influenced people's behavior in their day-to-day lives. The court said such so in a live law. So, coming to the next news headline, that about the PCP and DT Act, the Supreme Court asked the Union government to inform state steps taken for the enforcement, doing some amendments in the PCP and DT Act. The Supreme Court of India asked the Union of India to inform the steps it has taken to direct appropriate authorities for the initiation of punishment penalties for violation under the provisions of Preconception and Pre-Natal Diagnostic Act 1994 and related rules being mentioned in a year 2022 news headlines. So, another news, New Delhi, over the last 25 years, 617, that is the 617 convictions have happened under this act, doing 58 techniques that aims to check female feticide. Data up to December 2020 shows the number of ongoing cases under the law is 3,158. The number of medical licenses that have been suspended or cancelled stands at 145. So, these facts are highlighted as a part of observation and recommendation made by the Parliament Committee on Empowerment of Women in its report on the centers, that is a Beti Bachao Beti Padhao scheme. So, these data are very important, and our duty should be to reduce this data as the time passes. So, it is necessary to follow the act whatever being mentioned, and should not be there should be any violation. It should start from the public itself. Public should have a knowledge not to ask the medical practitioner to do the sex determination. So, it should start from a common man, so that, and if they knows anybody is doing so, report immediately. So, what all are the strengths of this act are the attempts to bring gender equality by prohibiting sex selection, comprehensive legal provisions, registration and monitoring of the particular center, laboratories and the clinic, awareness programs being done, and various measures to be taken for the implementation of this act. But still there are the few weakness or limitation of this act is the absence of local bodies, punishment not likely to create any deterrence, that should be very strict punishment against the persons who are doing such. So, enforcement barriers and lack of will by the state government. So, these are the few limitation or the weakness of this act to be removed or to be taken further to doing so amendments in this act. So, the conclusion of this lecture is the sex ratio is one of the important factors that determine the progress of the nation. Female feticide is an extended form of discrimination against women. The PCPNDT Act 1994 was enacted to curb the evil of sex selection and to eradicate female feticide, and being amended in the 2003. To broaden the scope of the act, the government has amended it and added preconception and ultrasound diagnostic techniques under its regulation. To accomplish the object of the act, joint efforts from governments, statutory bodies and independent social workers are demanded. So, these are the conclusions of our lecture about the PCPNDT Act, which was under 1994 and being amended in the 2003. So, these are the references the students can go to for further readings about the articles and the handbook, and one of the famous PubMed article, PCPNDT Act in a nutshell, in an Indian Journal of Radiological Imaging of year 2012. Thank you very much.